Dear participants, we would like to welcome you to our presentation entitled "The Role of Responsible State Institutions in Providing Protection During the Treatment of Complaints and Disputes from the Employment Relationship in the Republic of Kosovo." When a person feels damaged because a right has been violated, regardless of the category to which it belongs, he will feel violated and he will look for the opportunity to seek protection, respectively to return what has been damaged or lost, whether it is a material good or immaterial. In situations where a right that consists in the employment relationship is violated, this creates significant difficulties in terms of treatment and providing protection, since state institutions must be very careful in providing the right protection. The importance and the basic purpose of this topic is based on the need that at the present time the Kosovo society, the most difficult aspiration for every citizen is the establishment of an employment relationship based on the preparations and qualifications that they possess. Different factors affect the initiation of legal proceedings in which disputes from the employment relationship are the subject of appeal, such as discrimination in terms of gender equality, political interventions, nepotism, the lack of a proper institutional approach, bureaucratic difficulties within the organization. The cases of the termination of the employment relationship without a legal basis, the termination of the labor contract, the termination of the employment relationship unilaterally are some of the reasons on which this study will focus. The first objective of this paper is the observation of the legal framework, starting from the employer institution up to the judicial practice related to the disputes that arise from the employment relationships. The next objective is the categorization of the complaints received by the Independent Supervisory Council, depending on the object that was disputed during the years 2019, 2020, and 2021. This paper also follows the quantitative treatment of the inspection activity of the Labor Inspectorate in relation to the identification of employees who have employment relationships without formal contracts. Initially, the comparative method of interweaving the main legal sources with the secondary ones was used, through which the competent bodies act in treating complaints or disputes from the employment relationship. The second method is the research method through the interviews conducted with responsible officials of state institutions, specifically with judges who deal with civil cases, especially with disputes from the employment relationship. Statistical method was used to provide numerical data, in which case the number of complaints received by the Independent Supervisory Council for the Civil Services or for the Civil Service of Kosovo for the years 2019, 2020, and 2021 was presented. The above method was used to provide data that refer to the inspection activity of the Labor Inspectorate to present the number of employees who have established employment relationships informally or without labor contracts during the years 2020, 2021, and 2022. Labor law represents a branch of the positive legal system, which treats employment relationships as one of the relations that make up a special group of social relations with special importance and characteristics, Kosovo for a long time was part of the Republic of former Yugoslavia. Until recently, employment relationships were regulated by the Yugoslav law on basic employment relationships. Kosovo, until the law on labor was issued in 2010, was faced with a number of provisions distributed in many laws and regulations which were issued in different economic, social, and political circumstances. For a long time, since the Second World War, citizens of Albanian nationality were deprived of compliance with the provisions of the Convention on Discrimination in the Field of Employment and Occupation of the International Labour Organization. Albanian citizens in almost all forms of rights realization, including labor rights, were deprived of the main principle guaranteed by the Universal Declaration of Human Rights regarding the employment relationship. After the 19th, the former Yugoslavia began to disintegrate due to territorial claims. Then the entire autonomy of Kosovo is suppressed, and with this the right to work, where the Albanian citizens of Kosovo were deprived of almost every right, including that of establishing an employment relationship. After the end of the war in Kosovo, and after the approval of Resolution 2044, the international monitoring mission called UNMIK is installed in Kosovo. In 2001, the UNMIK mission managed to issue a regulation, which regulation was the only act that actually contained the designation as a law, or as it was called, the UNMIK Regulation on the Basic Law on Labor. The history of the regulation of the employment relationship continues to be accompanied by difficulties, since despite the establishment of temporary self-government institutions in March 2002, the government and the assembly attempt to issue a more advanced law, but without success. On April 30, 2010, the government of Kosovo approved the labor law, and this was the third time after 2006 and 2008 that the government approved this law, with some changes in content. The law on labor entered into force in December 2010 and constitutes the basic legal framework for the regulation of many aspects of the employment relationship. Among the legal acts within the national level, the most sublime act regarding the legal basis in a parliamentary state is the constitution of the country. The rights of employees not only include ensuring suitable working conditions, but also include protection against discrimination and exploitation in the workplace. Disputes should be understood as the situation in which a person claims to have a subjective civil right against another person, while the latter denies its existence, or for some or other reason denies his obligation to behave in a certain way. The employee whose right has been violated by the employment relationship can request its protection from the competent institutions, starting from the employer, the labor inspectorate bodies, the trade unions, or courts. The employer is obliged to create opportunities for employees to realize their rights from employment relationship. If these rights are not respected or employees are prevented from realizing them, a labor dispute is presented. According to the law on labor, the employee who believes that the employer has violated the relevant right from the employment relationship can submit a request to the employer for the realization of the violated right. The employer is obliged to decide according to the employee's request within 15 days from the date of receipt of the request. The employee who is not satisfied with the decision by which he thinks that his rights have been violated, or does not receive an answer within the deadline set by this law, in the following period of 30 days, may initiate labor dispute in the competent court. The court will always take into account the need for urgent settlement of eventual disputes. In the judgment by which the fulfillment of any obligation is ordered, the court sets the deadline of 7 days. Also, for this category of disputes, the law offers the most efficient possibility of protection where it determines that the deadline for filing an appeal against the judgment is 7 days. Many countries in the world today have special courts and specialized judges who judge only contested cases from the employment relationship. However, such a thing is not expected to happen in Kosovo because the law on courts does not provide for such a division, since disputes from the employment relationship are resolved by the basis courts. If the large number of cases and the small number of judges are taken as a basis, these disputes, despite the importance and advantages given by the law, remain untreated. If the court finds that the termination of the labor contract by the employer is illegal, based on the provisions of the law on labor, the collective contract, or the employment contract, it will order the employer to execute one of these compensations, to pay compensation to the employee in such amounts as the court considers fair and adequate, but which must not be less than twice the value of any compensation which belongs to the employee at the time of dismissal. If the dismissal is deemed illegal according to the law, the court may return the employee to the workplace and order the compensation of all wages and other benefits lost during the illegal dismissal. The employer is obliged to implement the decision of the competent court within the specified period. The Criminal Code of the Republic of Kosovo has defined the actions that consume elements of the criminal offense from the field of labor, such as violating rights in labor relations, violating rights of employment and unemployment, violation of the right to management, violation of the right to strike, misuse of the right to strike, violating social insurance rights, and misuse of social insurance rights. This research is based on judicial practice, which are in fact the most frequent cases that force employees to complain in court. From the evaluations of the judge, it is emphasized that in terms of the nature of the disputes that are presented, the most are requests for the annulment of the decisions of the employer with which the labor contracts were terminated in violation of the law on labor and other acts in force. Requests for restitution in the workplace with all rights deriving from the employment relationship, requests for annulment of decisions for candidate selection or cancellation of competitions, and lawsuits for annulment of employer's decision with which any disciplinary measure has been imposed on employees. The Independent Supervisory Council for the Civil Service of Kosovo is an independent body that reports to the Assembly to the Assembly of the Republic of Kosovo, which began to function in 2004 within the framework of the Ministry of Public Services. The functions of this institution are focused on examining and making decisions on complaints of civil servants against the decisions of the employment body in all civil service institutions in accordance with the rules and principles set forth in the law on civil service of Kosovo. Decide if the appointments of civil servants at the management level are made in accordance with the legal rules and principles. Supervise the implementation of the rules and principles of the civil service legislation. Civil servants of Kosovo and the applicants for employment in the civil service can complain to the Council, provided that the complaints must use the internal procedure of the employment body. At the end of each year, the Council prepares and publishes the work report with detailed data and information for all activities and works performed. From the work reports for the years 2019, 2020 and 2021, it can be seen that during 2019 the Council received a total of 784 complaints, which had a different object of complaints. As can be seen from the results, one of the issues that has been complained about the most is the disputed recruitment, which in our country is quite widespread as a phenomenon. After this, other complaint categories continue, accompanied by not very big changes, in which case the second one that ranks according to the report has to do with material compensations and requests with employment relationship or within employment relationship. In the same number, there were complaints regarding the termination of the employment relationship and disciplinary measures imposed on the employees due to non-fulfillment of duties and behavior according to the responsibilities defined by law. A small number of complaints were registered in categories such as demotion, against appointment of acting in duty, and career advancement issues. From the data provided, it can be seen a noticeable decrease in the submission of complaints in 2020. In contrast to the previous year, where at the top of the list of complaints were disputed recruitment, this year a total of 126 complaints were submitted that derive from the employment relationship. Material compensation has marked a slight increase with 4 complaints more than the previous year, while disputed recruitment have marked a marked decrease with 335 fewer complaints. In addition, there has been a decrease in the number of complaints regarding the termination of the employment relationship, disciplinary measures, transfers, and appraisals made in the framework of the work. Complaints for failure to enforce decisions of Complaints Commission and demotions remain the same, with minimal changes. However, unlike the previous year, this year there is an increase in the violation of the right to salary, with 30 more cases and 2 cases of non-extension of employment contract. Compared to the previous 2 years, the year 2021 has marked an enormous increase in terms of the submission of complaints to the Independent Supervisory Council. The data from the report indicate that the complaints from the employment relationship have continued to show a significant increase, which indicates that our society from year to year is facing dissatisfaction and irregularities in the exercise of the rights that are due to the law on labor. Mainly, during these 3 years, it is mainly these categories with the most reported complaints. The number of complaints regarding termination of employment and disciplinary measures this year was higher compared to the previous 2 years. Violations of the right to salary have marked a slight increase, while categories such as demotions, suspensions, career advancements, and non-extension of employment contract have a similar number in terms of complaints to this council. The Labor Inspectorate is competent for the supervision of the implementation of the laws in force, specifically the law on labor, the law on safety and health at work, as well as other laws such as the law on tobacco control, the law on strikes, the law on requalification and employment of persons with disabilities. The Labor Inspectorate is the primary institution charged with the responsibility of overseeing the implementation of these laws, which operates within the framework of the Ministry of Labor and Social Welfare. Also, this institution supervises the respect of these rights of the parties arising from the employment relationship. The law on the Labor Inspectorate has enumerated the responsibilities and functions of this institution, such as supervision of the implementation of the law on labor, working conditions and protection at work, provision of technical information and advice for employers and employees for the most effective implementation of legal provisions, notifying the Minister of the Labor and Social Welfare or any other competent body of any absence or misuse of the applicable law, providing information and advice to employers and employees in accordance with the law, and warning the competent authorities of any defects or misuse that are not included in the legal provisions. In order to implement the law from its area of responsibility, the authority of the Labor Inspectorate coordinates actions and cooperates with municipal governments, tax or health inspections, etc. If we analyze the inspection activity of the Labor Inspectorate during the last 3 years, it can be seen that the total number of employees who have been without a contract is a total of 2008 employees. Sharing this general result, during 2020, 460 employees exercised their activity in a non-formal way. In 2021, the exercise of working duties without labor contracts has marked an enormous increase, with a total of 192 employees without labor contracts. However, the year 2022 is characterized by a decrease in the number of employees without employment contracts compared to the previous 2 years. The report indicates that during 2020, 409 employees who were in informal employment or without labor contracts, and 8 economic entities were legalized. Meanwhile, during 2021, the Labor Inspectorate has influenced the legalization of a total of 345 employees and 29 economic entities. The work report for 2022 does not contain data regarding the number of employees without labor contracts or data for legalized subject or employees. In terms of the legal framework, The law on labor is a basic and general law that is dedicated to all employees, citizens in the Republic of Kosovo, obliging all public and private institutions to respect every provision that comes out of this law regarding the rights of work. At the national level, the rights from the employment relationship are firstly proclaimed and guaranteed by the Constitution of the country as the highest legal act in the hierarchy of legal acts. The paper indicates the progress and procedure of treating disputes from the employment relationship so that if the employee considers that his rights have been violated in this field, he can submit a request to the employer for the protection of the violated right as a first instance. The research indicates an increase in the number of complaints addressed to the Independent Supervisory Council for the Civil Service of Kosovo. The data indicate that during last 3 years, the year 2021 has been the year with the most complaints registered by the Independent Supervisory Council. Also, it is the same year during which the Labor Inspectorate recorded the largest number of employees without labor contracts. And for this conclusion, we would like to thank you for your time and thank you for your patience.